In this video, how to protect your assets from creditors, lawsuits, and divorce, a comprehensive guide. Asset protection is a critical concern for high net worth individuals, entrepreneurs, professionals, retirees, anyone navigating the uncertainties of creditors, lawsuits, and divorce. In 2025, with rising litigation, evolving divorce laws, and economic volatility, safeguarding wealth requires strategic planning and proactive measures. This guide explores practical strategies to shield assets, focusing on legal structures, legal tools, financial tools, jurisdiction options. Everything in this video is going to be 100% legal and grounded in current trends, and we're going to outline the steps, benefits, and considerations to help you secure your financial future with confidence and protect your assets. So, why does asset protection even matter? Asset protection involves structuring your wealth to minimize exposure to risks, such as creditors' claims, lawsuit judgments, or divorce settlements. These threats can arise from business liabilities, professional malpractice, personal debts, or marital disputes. The goal is not to hide assets, quote unquote, but to legally organize them to deter claims or limit losses. In 2025, asset protection is increasingly vital due to the surge in litigation in the US. It's insane. Lawsuits in industries like healthcare, real estate in particular, and technology are rising, with US courts seeing over 400,000 civil cases annually, many targeting higher net worth individuals or businesses. Stated another way, once you get rich enough, you're gonna get sued eventually, so you're gonna want to have this asset protection plan in place beforehand. It's like, don't wait till you're rich to start doing asset protection. Think like someone that's already rich and start acting like a rich person would act. Start doing what, yourself 10 years in the future wishes that you would do today. Because once a lawsuit starts or a divorce starts, it's basically too late. And we'll get into that a bit more in the video. But, one of the other reasons it's increasing is obviously divorce trends are increasing as well, hovering at around 40% in many Western countries, and courts are increasingly favoring equitable asset distribution, right? So protecting personal wealth is critical, especially wealth that you're bringing in to the marriage from before the marriage. Effective asset protection requires foresight, acting before a claim arises, and a combination of legal, financial, and jurisdictional tools tailored to your circumstances. So let's go over some key asset protection strategies. Several strategies can shield assets from creditors, lawsuits, and divorce. Each offers distinct benefits and requires careful implementation to ensure compliance and effectiveness. So number one is trusts, a cornerstone of asset protection. Trusts are legal entities that separate ownership of assets from control, placing them under a trustee's management for designated beneficiaries. They are a cornerstone of asset protection due to their flexibility and legal robustness. So one type is a domestic asset protection trust, a DAPT, available in jurisdictions like Nevada, Delaware, or South Dakota, which allows you to be both settlor and beneficiary while shielding assets from creditors. In 2025, 19 US states recognized DAPTs, requiring assets to be transferred to the trust before a claim arises. A clean financial history is essential, as courts may void transfers made to defraud creditors. The next type is offshore trusts. Jurisdictions like the Cook Islands, Belize, or Nevis offer strong protection due to strict privacy laws and high legal barriers for creditors. Offshore trusts deter lawsuits, as foreign courts rarely enforce US judgments, and legal costs for creditors are prohibitive. Setup costs range from $10,000 to $30,000, with annual fees as well to keep the trust active. So offshore trust probably only makes sense beyond a certain threshold, probably $500,000 in assets and above, but it's increasingly common and it's become increasingly democratized as well. 30 years ago, trusts were like this fancy thing, but now there's YouTube videos about it. We just made a video about Nevis, LLCs, and trusts. And so this pathway is more open now than ever. And by the way, MyLatinLife, we specialize in all things offshore. So if you're looking to lower your taxes, you're looking to set up an offshore trust, we can help you do that. So there's a link in the description to book a call with us. Book a one-on-one consultation. We'll answer all your burning questions, and we can get the process started to protect your assets, spin up trusts, spin up LLCs, get you multiple residencies and passports, whatever you need to do. If you're ready to take action, link in the description to book a call. Now, the third type of vehicle that I'm going to talk about is irrevocable trusts. By relinquishing control of assets, irrevocable trusts remove them from your estate, protecting them from creditors and divorce settlements. They are effective but require careful planning, as assets cannot be easily reclaimed. So, moving on to some benefits of trusts in general, they reduce your taxable estate. They deter frivolous lawsuits and protect assets from divorce by removing them from marital property. Offshore trusts offer additional privacy, as jurisdictions like Nevis are outside the OECD's Common Reporting Standard, the CRS. And if you don't know what the CRS is, again, we have another video on our channel about that too. So some considerations: trusts must be established before claims arise to avoid fraudulent transfer accusations. Offshore trusts face scrutiny for tax compliance, requiring expert legal guidance. If you're American, it's very different than if you're Canadian or European and where you're a tax resident of. So everybody's situation is a little bit different, so costs and complexity do vary. Moving on from trusts, next I want to talk about limited liability entities, business and personal separation. Structuring businesses or investments through limited liability entities such as LLCs or corporations, which separates business and personal assets, limiting exposure to lawsuits or creditors. So starting with LLCs, which stands for limited liability companies, LLCs are popular for their flexibility and strong protection. States like Wyoming and Nevada offer single-member LLCs with charging order protection, meaning creditors can only access distributions, not the LLC's assets, which is pretty cool. For example, a real estate investor can hold properties in separate LLCs, shielding personal wealth if one property faces a lawsuit. And by the way, if you need a Wyoming LLC, we have a service for that as well. The next vehicle is corporations. So C corporations or S corporations protect business owners by limiting liability to corporate assets. They are ideal for professionals like doctors or lawyers facing malpractice risks. And the third vehicle I want to mention is series LLCs, which are available in certain states like Delaware. And basically, a series LLC allows multiple quote-unquote cells within one entity, isolating assets such as rental properties from each other's liabilities. The benefits of limited liability entities such as LLCs and corporations is they can be very cost-effective to set up and maintain. They protect personal assets from business debts and limit divorce exposure by classifying business interests as separate property. So some considerations are proper maintenance, separate bank accounts, compliance with state filings. These things are critical to avoid what's called piercing the corporate veil, where courts disregard the entity's protection. Multi-jurisdictional businesses require careful tax planning. Now, the third strategy I want to mention is homestead exemptions and protecting your home. This is how you can shield your primary residence from creditors in many jurisdictions. In 2025, states like Florida, Texas, and Iowa offer robust exemptions, often protecting 100% of the home's value if it qualifies as your primary residence. So the eligibility there is you must occupy the home as your primary residence. Some states cap the exemption, such as in California, it's $170K, while others, like Florida, have no value limit for homesteads within certain acreage restrictions. The process is you file a homestead declaration with your county recorder, a simple process costing $20 to $50, and just ensure that your mortgage and tax payments are current to maintain eligibility. The benefits of homestead exemptions are automatic in some states and protect against forced sales by creditors, though not against mortgages or tax liens. They also reduce exposure in divorce by prioritizing the home as a protected asset. So some considerations here: the exemptions vary widely by jurisdiction. So states like New York offer limited protection, California is limited protection, but Florida and Texas have more robust protections. Bankruptcy filings may override state exemptions, requiring federal limits, such as about 28K in 2025. So something to keep in mind there. Now, the fourth strategy is retirement accounts, which actually have a lot of built-in protections. Retirement accounts like 401ks and IRAs offer inherent protection under U.S. law. What's called a ERISA qualified plan, such as a 401k, are fully protected from creditors and bankruptcy, while IRAs are shielded up to 1.51 million adjusted for inflation. So the strategy here is to maximize your contributions to retirement accounts to place assets beyond creditors' reach. Roth IRAs with after-tax contributions offer tax-free growth and protection. And then divorce considerations. Retirement accounts may be divisible in divorce, but structuring contributions early and consulting a family law attorney can minimize exposure. So some benefits of the retirement accounts is it's definitely the lowest cost strategy that we've talked about so far to maintain and offer tax advantages alongside creditor protection. They are ideal for long-term wealth preservation, and it's usually free to set up a 401k, right? Whereas, an LLC might cost you $500 or something, at least a 401k or IRA is free to set up. Keep in mind that there are contribution limits. So it's $23,000 for a 401k or $7,000 for an IRA in 2025. And so you're kind of restricting the amount that you can shield annually. And remember that withdrawals before age 59 and a half may incur penalties limiting liquidity. Now, the fifth strategy I want to mention is jurisdictional diversification. Offshore accounts and entities. Relocating assets to jurisdictions with strong privacy and legal protections reduces exposure to domestic claims. In 2025, countries like Switzerland, Singapore, and Panama offer stable banking systems and favorable laws, where you can do offshore bank accounts. Accounts in jurisdictions outside the CRS, like Panama, provide privacy and deter creditors due to high legal barriers. And actually, I take that back. I think Panama has joined the CRS, but there are a number of other CRS countries in Latin America, including Paraguay, which I think signed on to join the CRS, Guatemala. So there are a couple. I think Dominican Republic as well. You can watch the other video on our channel that'll give you more of the list. Another strategy here is offshore LLCs or corporations. Entities in jurisdictions like the BVI or Belize or Guatemala is surprisingly popular. Shield assets in a way that's similar to trusts. And sometimes an offshore corporation can actually be cheaper to set up than a trust, but usually kind of around the same. So some benefits here: offshore strategies offer privacies, they deter lawsuits, and they diversify your risk across jurisdictions. Just consider that it'll require additional compliance with tax reporting, such as FBAR in the US, and the setup costs are a little bit higher. And, of course, you might have to deal with currency exchange risks or regulatory changes like potential CRS inclusion, which, necessitates ongoing monitoring. So subscribe to the channel MyLatinLife because we're constantly putting out new info every day about changes regarding jurisdictions and internationalization. Strategy number 6 is prenuptial and postnuptial agreements. Divorce protection. Prenuptial is obviously before marriage, and postnuptial is after marriage. And these are agreements that define asset ownership, protecting wealth in divorce scenarios. So some key provisions here is specify separate property, like premarital assets and inheritances, and outline division of joint assets. Include clauses for business interests or trusts. And the process is, work with a family law attorney to draft enforceable agreements. I think there's even some softwares now that are helping with some of these prenups, but both parties must disclose assets fully and sign voluntarily. So there might even be an idea where you would set up trusts and do things to reduce your assets before you even do the prenup. So some benefits: these agreements clarify asset ownership, reducing disputes and divorce. They complement trusts or LLCs by reinforcing separate property status. And then some considerations here. Agreements must be fair and transparent to withstand court scrutiny. Jurisdictional differences, such as community property states, affect enforceability. So let's compare all the different strategies that we've gone over so far because each strategy suits a different need. Trusts are best for high net worth individuals seeking comprehensive protection from creditors and divorce. Offshore trusts offer maximum security but require higher costs and compliance. LLCs and corporations are ideal for business owners or investors separating personal and business liabilities. They are cost effective but require diligent maintenance. Homestead exemptions are suited for homeowners prioritizing residence protection, especially in states like Florida or Texas. And then retirement accounts are effective for long-term savers, maximizing tax-advantaged creditor-proof accounts. More offshore strategies appeal to those diversifying globally, doing offshore LLCs and offshore businesses, right? Online businesses, offshore businesses, they very much go hand in hand with global diversification. And then prenuptial and postnuptial agreements, which are essential for individuals entering or in marriages, complementing other strategies. Combining multiple strategies, such as a trust with an LLC and a prenup, creates layered protection tailored for your risk profile. So don't think you only need to do one of the 6 or 7 strategies we've mentioned. You can definitely pursue multiple of these strategies, and we'd recommend pursuing multiple of these strategies. Some potential drawbacks include the costs. Trust and offshore entities involve significant setup and maintenance fees, and legal assistance is often necessary. And then the complexity. Navigating trust laws, offshore regulations, or entity compliance requires expertise. Fraudulent transfer laws penalize last-minute asset shifts. Another drawback is liquidity. Irrevocable trusts or retirement accounts limit access to funds, which may not suit those who need liquidity and flexibility. And then jurisdictional risks is something to consider. Offshore strategies face regulatory scrutiny, and domestic laws vary widely, requiring tailored planning to your specific situation. Another drawback is divorce challenges. Even with agreements, courts may challenge asset divisions, especially if perceived as unfair or hidden. So who should pursue asset protection? Well, everybody, of course, but let's break it down into 5 categories. So the first category is entrepreneurs and professionals. Those with business or malpractice risks, they benefit from LLCs, corporations, and trusts. The next group is high net worth individuals. Trusts and offshore strategies suit those with significant wealth exposed to lawsuits or creditors. Group 3 is retirees. The homestead exemptions and retirement accounts protect fixed incomes and homes. Group 4 is married individuals. Prenuptial and postnuptial agreements and trusts safeguard assets from divorce. And then Group 5 is global nomads. Offshore accounts or jurisdictions like Paraguay appeal to those seeking privacy and tax advantages. In conclusion, protecting assets from creditors, lawsuits, and divorce demands proactive strategic planning. Trusts, LLCs, homestead exemptions, retirement accounts, offshore strategies, and prenup agreements offer robust tools to safeguard your wealth, each tailored to specific risks and goals. By acting early, engaging experts, and combining strategies, you can create a layered defense that preserves financial security. Jurisdictions like Paraguay, Panama, Guatemala, Nevis, they enhance your options with tax advantages and privacy, while domestic tools like DAPTs or Wyoming LLCs provide cost-effective solutions. Despite cost and complexity, the peace of mind and financial freedom gained make asset protection a worthwhile investment. Start today to secure your future against unforeseen challenges. And if you take anything away from this video, it's the importance of starting early, because if you transfer the assets too late, it can be totally voided. So you need to do this before you need it, right? So thanks for reading. If this video was helpful, please give it a like, subscribe for more financial insights, and share your thoughts in the comments below. Are you exploring asset protection strategies? Your feedback fuels our content, so we'd love to hear from you. And if you're ready to take action, if you want a Wyoming LLC, a Nevis offshore trust, a Panama corporation, whatever you need, book a call, link in the description, and let's start taking action. And we'll see you in the next video.